So in this module, we're going to be looking at defenses. So let's assume that someone accuses you of a crime. You might just say, no, I didn't do it because I didn't do it. So you could be actually innocent of the crime. Someone could accuse you of a crime and you could say, well, I see why you would say that, but no, I did something, but it wasn't a crime. So yes, you did see me driving your car without your permission, but it's not the crime that you're accusing me of, right? Your spouse gave me permission because your spouse needed me to help him do something. So I see why you may say that because you see me, I'm driving your car without your permission, but that's actually not a crime because your spouse, who also owns this vehicle, gave me permission. So the first response is just conjecture, no, I didn't. The second one is, well, no, because I didn't meet the definition of the dumb crime, right? I see why you would say that I was stealing your car because I was driving it without your permission, but don't forget, you're married and your spouse gave me permission. Third response would be like, oh yeah, probably did technically steal your car, but I had a really good reason for doing it. And then the final response would be something like this. You stole my car. You just accused me of a crime, sir. This is the wrong place and time to have this conversation. File charges and I'll see you in court. So those all relate to something called stasis, the stasis of conjecture, the stasis of definition, the stasis of degree, and the stasis, what I call time or place, that this is just not the right time or place to have this discussion. The stasis of degree is, well, I may have done what you say I did. I may have met the elements of the crime, but I had a really good reason for doing so. And then the stasis of definition is, I don't actually meet the definition of the elements. You can't prove them all. Because of X. So when we're looking at these defenses, they all actually neatly fit into one of those four categories. You don't need to know this for the exam, but it is interesting philosophically just to think about historically for thousands of years, people have thought about how to respond to arguments and how to respond to cases being made either for them or against them in very similar ways. So the affirmative defense is what we're going to start with. An affirmative defense is either an excuse or justification, and I'm also keenly interested in excuse and justification. I have written a paper on them and these two terms, and don't worry, I'm not going to bore you with it. But an excuse, the way I normally teach this, an excuse is I usually say the word partial excuse, and then I use the word full justification. And I realize that when I say partial excuse, that is redundant. And when I say full justification, it's redundant. But I want students to be mindful that a justification, which in most cases means that society praises you, and an excuse has a range, but is still in some sense partial. So you may be excused to some degree from criminal liability, but you may have still done something that was wrong. So society doesn't necessarily praise you like society might if it was a full justification. So think about this. Justification would be something like self-defense, whereas excuse may be, well, you killed someone, but it was in the heat of passion. So you may be partially excused. You're not going to get the murder one, but you still did something wrong and you should be punished. And those are generalizations. I'm overstating the case when I say these things, but let's look at some of the affirmative defenses. So immunity. Yeah, I may have done it, but I have immunity from the government, so you can't prosecute me. Duress. Yes, I robbed the bank. I am the bank president, but they had my wife and children hostage, and they had gun pointed at each of their heads. And so, of course, I did it. I would do it again. I was under duress. So you're not denying that you committed the crime. You're just saying there was a really good reason for me to do so. Alibi. Now, I don't consider alibi to be an affirmative defense. I think an alibi is typically an actual innocence defense. So just you can make that note. Hey, my professor doesn't think alibi is an affirmative defense. I think alibi is when you're saying I was physically not there, I was actually innocent. Like, that's my twin who did that. I was over here. There's an interesting case that I have pulled for you to review with regard to Alibi. All right, violation of double jeopardy protection. I've already been tried for this, so maybe I did it, but you can't try me twice. And then violation of a speedy trial. Hey, I may have done it, but you waited too long to try me. All right. Affirmative defenses. So immunity defense, double jeopardy, and statute of limitations. The prosecution's just barred. You can't do anything about it. I might be morally culpable for it. Morally culpable. Like, I'm actually a bad guy for doing what I did, but you can't do anything about it because I have an immunity defense. Then there's defenses that, if proved, they actually vitiate or negate or cancel an element of the offense. This is Stas's definition. So a good faith belief that property wasn't stolen negates the knowing element of crime. If you were to take an umbrella from a restaurant thinking that it was yours, it's not criminal, right? Because you thought it was yours. There was no intent to deprive someone else of their personal property. Then there are defenses that serve as justification. You actually did something that was right, that is the necessary force used in self-defense or the defense of others. And then there's some defenses that excuse the criminal act in a different way from the, well, you can't do anything about it, immunity defense, or, well, I see why you may say that, but I don't meet the elements. Like, you can't prove all the elements. There's one that's missing. And this one is, I don't have the element of mens rea because of insanity. Like, I don't understand right from wrong. So what does immunity look like? So this is actually very interesting. Again, fodder for discussion. Diplomatic immunity. Have you ever seen that on TV or news? What is a diplomatic immunity? It's an international agreement regarding government officials stationed in a foreign country. Diplomatic immunity may be waived by the diplomat's home country. In the case of serious crimes, the U.S. government frequently requests that waiver. But if you're a diplomat, you're subject to this protection of diplomatic immunity. You can commit crimes in U.S. soil, and we can't do anything about it. Legislative immunity is granted to those men and women that we have elected. It's temporary. Typically, when those legislative bodies are in session, charges could be held until the legislative body adjourns. It's temporary. And then, if you understand jurisdiction from Chapter 2, obviously state legislatures, you can't grant immunity for prosecution for federal crimes. That just makes sense, I hope. And then there's witness immunity. And this is what you're going to be dealing with mainly in law enforcement, prosecution, defense, is when you grant a witness immunity. So someone turns what they call state's evidence. So prosecutors have the power to subpoena witnesses to give testimony. Under the Constitution, the Fifth Amendment, a witness cannot be compelled to testify against himself. So to resolve this conflict, United States and state governments have passed various immunity statutes. So there's use immunity and transactional immunity. So transactional immunity, if granted, the witness cannot be prosecuted for any offense related to the subject matter of his testimony. This is sort of all-encompassing. Use immunity allows that the statements made by the witness may not be used in subsequent prosecutions, but the witness can be prosecuted for the crimes about which they testified if other evidence is used. So which one do you want if you're the defendant? Clearly you want transactional immunity. Use immunity is weak. Transactional immunity is the all-encompassing immunity. So these are interesting defenses or attempted defenses. That is mistake of fact or ignorance of a fact. Not knowing the law, that is ignorance of the law, is generally not an excuse for anything. Mistake of fact might be. Ignorance of a statute that makes failure to place infants or child in a car seat is not a valid defense. But if a man mistakes his coat for someone else's coat, the umbrella, right, it may be a defense. A mistake of fact, when you get to those other exceptions for strict liability, mistake of fact is not a defense. So having sexual intercourse with an underage child, so under the age of, let's say, 17 or 18, depending on your state, requires no knowledge of age. There's no mistake of fact defense based on mistaken belief of child's age. What results if you're talking about 24 hours until someone turns 18 and misrepresentation by the minor? In certain circumstances, there may be some further questions to ask about justice in those cases. Intoxication or drug defense. So intoxication, your condition is intoxicated. So voluntary intoxication or voluntary drugged condition is rarely successful. Rarely. Some states have abolished intoxication as a defense in any case. I'm not entirely sure about this, but from your textbook, Montana, some state statutes allow charges to be reduced. Right now, this is voluntary intoxication. Okay, voluntary intoxication. Involuntary intoxication can be a defense. Now, you have to convince a jury of this, but if someone slips a Mickey or there's some other, you don't know that you're drinking, and then all of a sudden you're intoxicated, you didn't know it, you weren't counting your drinks, that actually could be a defense because the things you're doing are not voluntary. And then if you become so intoxicated you can't tell up from down, it potentially could negate mens rea, one of the elements. But think involuntary intoxication, when somebody sort of sneaks something in on you, different. Voluntary intoxication, yeah, good luck trying that one. But you could see why it might be compelling for people to try. Duress, coercion, or compulsion. So threats must put defendant in fear of imminent death or serious bodily harm, which can only be avoided by engaging in the coerced criminal conduct. So a mother forced to traffic drugs as a result of a child being kidnapped. That's okay. Threats must be such that a reasonable person in the defendant's circumstances would be unable to resist the threats. But what result if someone says, I'm going to kill your child unless you go assassinate someone? I'm going to kill your child unless you go assassinate someone. Probably not going to be a defense. It may be a partial excuse, but not going to be a defense to take someone else's life. Necessity, a defense to criminal prosecution on the grounds that the harm to be avoided outweighed the harm caused. A driver wrecks his or her car and walks in the freezing snow to find help for the family member trapped in the car. Seeing that no one is at home, the driver breaks into the home and uses the phone. Now, you would be responsible for damages to the home if you broke a door down, but this defense might be accepted. It might be. So certainly, what if you were avoiding hitting a child and you yanked your steering wheel and you ran it up and you killed someone's dog and you destroyed their property? Well, if you saved a child's life, poor puppy, and I don't really care about the yard, but that's probably going to be a necessity defense that would be accepted. This is old law. Rex v. Dudley and Stevens is very interesting as well. But can you kill to save your own life? Yes. Yes, you can. There are certain circumstances that must be the case, but you can. So, alibi. In the defense of alibi, the defendant is asserting that he or she physically could not have committed the crime because at the time the crime was committed, he or she was in another place. Alibis are effective if you can convince a jury that you were someplace else because what? You can't be in two places at the same time. So the burden is on the state. So this is actually fun and tricky. The burden is on the state to show beyond a reasonable doubt that the defendant was at the scene and committed the crime. It's not on the defendant to show he was not at the scene. But if the defendant can show that he was not at the scene, then the state can't prove beyond a reasonable doubt that he was. Because alibis can be made up, they have to be carefully investigated. Some states, you the defendant actually has to serve notice before trial to the prosecutor that he or she is going to use this, so that they have time to investigate things like credibility, or perhaps they could prove some other way. The general rule is that one who performs a criminal act under the advice, direction, or order of another cannot use such as a defense. What if you ran a red light? What if you ran a red light? It was red. You were stopped, and then you went right through it knowingly. Well, that's a crime, isn't it? What if a police officer told you to do it? What if a police officer pointed at you and said, go through this light, I'm directing traffic? Well, certainly you should obey the police officer. If a police officer steps in and directs traffic, then the traffic signal is no longer the authority figure in the room. But you can see that it's possible, but very unlikely. If you say, well, he told me to do it, and he was my boss, probably is not going to mean jack squat to anyone. But if it's an official, like a police officer, or if you are that police officer and you tell someone to go through, they better go through, or they can be arrested, right? So they need to run that red light, but you're telling them to, so it's okay. It would be a defense if anyone was weird enough to actually charge them. Double jeopardy means that a person who has been acquitted or convicted by a judge or jury may not be tried for the same crime. Now, I'm going to jump right ahead. If you rob a bank, it's federally insured, FDIC insured. The federal government, the United States of America, can bring charges against you. And if you did that in the state of Texas, so can the state of Texas. You can actually be tried twice because there are different elements involved. It's real tricky. Pay attention to this when you get to that section in your textbook as you're reviewing. In the case of a mistrial, the double jeopardy clause typically does not bar another prosecution because there has been no final decision. Retrial after a hung jury is not double jeopardy in a single count prosecution. Double jeopardy does not bar successive prosecutions of a defendant convicted of one offense if the subsequent prosecution involves different elements or a separate offense. Just keep that in mind. Lots of case law on this. So separate prosecutions are permitted where the criminal had multiple victims. So Andrea Yates drowned her children. Let's say there were 5 children that she drowned. The state of Texas could prosecute her for 1, for 2, for 3, for 4, for 5. It could do 1 at a time. It could do 2 and then 1 and 3. Or 2. I can't add. 2 and 1 and 2. It could do 3 and 1 and 1. So that's not the same thing because there are multiple victims, there are multiple crimes. Just keep that in mind. But double jeopardy does not apply to a second prosecution if the offense charges a separate offense, if they're different elements. Just keep that in mind because it gets a little bit tricky when you have a crime that's both federal and state, and it's just about the same thing but not exact. If it's not exact, probably not double jeopardy. Res judicata is the doctrine stating that once an issue has been determined between 2 parties, it cannot be relitigated by those parties. Collateral estoppel is a doctrine stating that a fact necessarily found in one trial of a defendant bars proof of the same fact in a second trial. So res judicata and collateral estoppel are actually interesting doctrines, and they're not merely criminal law doctrines. I have a case right now that has to do with res judicata and collateral estoppel. I won't tell you more about it because it's an ongoing case. But it is a civil case, not a criminal case. But res judicata, collateral estoppel. So these are key, and these are actually larger than criminal law. In fact, I have not ever been involved in a criminal law case where there was a res judicata issue. I have been involved in a number of arguments, at least in civil cases, where res judicata was at issue, or collateral estoppel, sometimes both. So in class, in a residential setting, I will make a very large joke about entrapment. It's very hard to prove entrapment defense. It's very hard. I'm just telling you, very hard. So entrapment is not accepted at all in homicide cases. So it's based on an official action that induces a person, and that person was not already predisposed to criminal behavior. So if you induce someone who was not ready and willing to commit the crime, maybe you have an entrapment defense. This is to protect people from the government. So this does not apply to actions by private people. This is about the government action. So what does an inducement look like? It goes beyond usual investigation techniques. Simple solicitation by officials to commit crime is not enough. It must be repeated or persistent, coercive encouragement, or aggressive persuasion. So you just imagine, even if you didn't believe me, law enforcement officers lie all the time. They convince people to do drug deals all the time. Entrapment very rarely attaches, because it has to be this repeated, persistent asking, or really being coercive, being aggressive. It's very hard to prove, but it still is a defense. So the defense that another person committed the crime, I would argue, is an alibi category. You have the wrong person. It wasn't me. I was someplace else. And how do you add evidence to that? Well, it's a different person. So think about in sexual assault cases, or even just assault and battery cases where there is blood or fluid. Like they find the blood of the person on the tooth because he punched him in the face. In the blood of the perpetrator, there's enough, and they find out that it's A positive. The person arrested is not A positive. And he says, I was someplace else, and that blood is not mine, and I have no cuts on my hand. So think about the kind of evidence that you could present. So this kind of evidence is called exculpatory evidence, and that is the easiest way to present your case that it was another person who committed the crime. Obviously, in a sexual assault case, let's say there were bodily fluids, seminal fluids, something like that, and you could swab, and you could get the victim to submit to testing, or at least for like a rape kit in the hospital to preserve this evidence. And then the person who's been arrested, it's just different DNA. That could be very substantial exculpatory evidence. It wasn't me. It was someone else. I may look like the guy, but it wasn't me. And I was over here. So I consider this to be of the category of an alibi. It wasn't me. Although the alibi means I actually have evidence I was someplace else. This is, I have evidence that someone was in the place you said I was. So I think it's the same kind of category. But it's pretty straightforward. So if you're into forensic laboratory kind of science, this is obviously a big deal with DNA. And before that, something as simple as fingerprints. We have the fingerprints of the perpetrator, and then you collect someone, bring them and charge them, and then you get their fingerprints, and they're totally different, like exculpatory evidence. Right to speedy trial. I have only used this one time, and I was successful, sort of. So I don't do criminal defense, but I have, on a few occasions, helped someone out who did not have sufficient funds to hire a defense counsel, where I thought it was a friend of a friend, something like that. I think on 3 occasions. This was one of them. And eventually got, it wasn't a very fancy case. It was a Class C misdemeanor for possession of drug paraphernalia. We got the case dismissed. And I believe it was dismissed because there was no evidence, but things culminated because I threatened to file a lawsuit because they were violating, I say they without being specific, violating my client's constitutional right to a speedy trial. It had been over 2 years for a Class C misdemeanor, and eventually the prosecution did the right thing, and they were perfect gentlemen about it. But I'm not so sure that in the appellate courts I have seen the speedy trial defense successful. You could use your access to LexisNexis to look that up to see if there had been anything recently or in the past to see what kind of circumstances might create this appropriate circumstances for a speedy trial defense, but it does exist. It's going to be a sort of a fact-finding. Here it says balancing test, length of, and the reason for delay. So if it's not the prosecution's fault, then it's not the prosecution's fault. If the prosecution is doing something untoward, then maybe you could use this. If the prosecution is like, hey, there's just a backlog. Well, that's frankly not on the prosecution. However unfortunate it is for the defendant, if the defendant is not guilty, is innocent, in fact, it's unfortunate, very unfortunate. But if the prosecution is doing everything, let's say there's one prosecutor, he or she is doing everything that she can, then that's not on the prosecution. And so the interesting defense, right to a speedy trial, is a constitutional protection. We're going to talk about some other constitutional protections here in the next few modules as well. This defense is an affirmative defense in this sense. Maybe I did it, maybe I didn't, but it's been too long and you cannot charge me with this crime. This is a very, very powerful defense. There's a certain amount of time that the state of Texas or your state or the United States of America has to bring charges against you. You have to file a lawsuit in civil side, same way, within a certain amount of time. And you are limited in that amount of time. And if you wait even one day too long, the defendant can raise the defense of statute of limitations. There's all sorts of reasons why we do this, but this is a very powerful defense. It would trump everything. It's very easy to prove for the most part. And if you can prove it, it's 100% successful. I say that, and I probably shouldn't, because there may be some tolling statutes and some other things that allow for a little bit of wiggle room. But for the most part, statute of limitations is very, very powerful if it applies. Be mindful that some crimes do not have a statute of limitations, period. So just think of, I don't know if you've ever seen the TV show or heard of it, Cold Case. Why would you have a cold case TV show if there was a statute of limitations? It happened too long ago. So murder has no statute of limitations. That's how we have TV shows called Cold Case, because you can revive them 50, 100 years later. Unsolved murders. There's some others as well. I believe it depends on your state, but you wouldn't be surprised in some states to see sexual assault of a child either having a very long statute of limitations or an unlimited statute of limitations. So as you're going through this chapter in this module, try to keep all these defenses straight. Know that this is one of the most important areas of criminal law you will study. In law school, you might very well study a few crimes in your criminal law class and spend the rest of the semester on defenses, because as you learn how a defense works, how it can be applied, and the cases that have applied it, and the facts, as you learn those and you add nuance, you are understanding the elements themselves. So it's good pedagogically, and it is also, these are where the arguments come in, the defenses to criminal charges.